Hi, everybody. Thank you so much for joining me. I am Maureen, and I am the owner and founder of BarMD, a bar prep company. We specialize in the UBE and in the California bar exam. And today we're doing a workshop to review and discuss the February 2023 California performance test. So that's why you're here. I put a link in the chat. I put the file that has the materials in the chat, so check that out. You can open it to kind of walk through it with me as I draft. So first, let's get this. First, I'm going to do some background. All right. So goals for today: understand the February 2023 PT. Understand the performance test process, understand how the performance test is written, and how to organize the performance test. So we're going to talk about all of these things. So that's what we're covering today, primarily through the points 2, 3, and 4. We're really covering through the review and the understanding of the February 2023 performance test. So first, I want to walk you through the performance test process. So performance tests all have two booklets, basically a file and a library. Within the file, the first actual document is what we refer to as the task memo. My dog is going to join us for some of the meeting. This is Archie. Thanks, Starla. Archie will join us here. So the first document that's really substantive that is in the file is the task memo. I'm sure you're all pretty familiar with that. And if not, that's all right. The first thing you want to do is you want to open up your materials and you want to get right to that task memo. And I have timing here, which I'm going to talk through in a minute as well. You're going to go through that task memo, read it, make some notes. You're going to identify a few things that I will walk you through. Second, you're going to set up your PT, what I call the skeletal outline of what your headings and subheadings in your, what I call the macro headings, your introduction, your analysis or argument heading, and your conclusion heading. And then you will also include, if you can, your micro headings, which are the headings that are within the analysis or argument section. You want to include those, identify those as quickly as you can. I refer to these as your organizing principles. It's really how you organize the meat of what you are writing. If you're writing a closing argument, if you're writing a memo, if you're writing a brief, whatever it is, how are you organizing the bulk of it? So hopefully you get that from the task memo, but not always, as we saw in the February 2023 PT. All right, so you do a quick setup, and you're actually doing this in your exam file. You're doing this on your computer, you're setting it up. So we're gonna go kind of back and forth between, looking at your materials and typing a little. And I do that really the same time. I do that as a time-saving measure. All right. I'm going to pause for just 1 second. If there's any questions that people have that want to put in the chat. Okay. And let me know if at any point internet's a little shaky. Just let me know in the chat, and that way I can pause for a second as well. So step three is you just do a quick file. And I really like to skim the file before I get into the library. Some people like to actually read the file first and then read the library. This is something that you should mess around with and practice. I have a very strong preference, and I definitely advise, skimming the file and then going on to the library, because you're going to go back and actually read the file. So you're just going to do a quick skim of the file. I'm going to walk you through doing that today. And then also, after you do that, you skim and read the library. So you skim and read, and you skim part of the case until you get to what's really important. So you know what's really important once you hit the procedural history, and then we slow it down. And I'll definitely walk you through doing this today as well. You're reading each case with a purpose. If you know what your headings are in your argument or analysis section of your task, then great, you're identifying, what am I using this case for? Am I using it for issue 1? Am I using it for issue 2, etc.? So you read each case with a purpose. Identify why the bar examiners gave you that case or gave you that statute. Why did they give it to you? Want to really make sense of that. And you also really want to focus on the analysis of the issues in the case. That's where the meat is. We want to, of course, extract rules. And then we want to look at the analysis. How did the court apply the rules to the facts of the case? Because we're going to use that information. We're going to use that analysis to analogize to or distinguish from our case. So that's really like a huge part of the performance test, right? Is that analogizing and distinguishing from the case or cases in the library. Assign cases to their appropriate issues. So assign cases to their appropriate issues. We're going to just make an annotation in our actual answer of where I'm using, what I'm using each PT for, or I'm sorry, what I'm using each case for, each rule, where does it go? What issue does it go towards? And identify where to draft rule explanations, if you call them. So let me just take a little step back here. For all of you that were, hopefully you have an understanding, if you've done like your first year of legal writing in law school, if you're a foreign trained attorney, hopefully you have some experience with this. If not, you should definitely get the book, because I really do walk you through doing this. I mean, for anybody. But especially if you did not go to law school in the US, because it can be a little bit more difficult if you weren't trained to write this particular way, which is part of the curriculum in law schools in the US for legal writing. So what you have to do, you have to follow what is generally called, I call it a, so what is generally called like a CREAC or an ERPAC. Some people call it IRAC, but this is different from IRAC for essays, because there's an extra component, which is the rule proof. So I'm going to talk about this a little bit. And this is a shorter workshop. In my full courses, I go through all of this in great detail, but we'll definitely explain some of it here. So one of the components of your IRAC for a PT, or your CREAC or ERIAC, I've seen BARIAC, whatever it is what I call a rule proof, which is demonstrating how the court in the case that's given to you in the library, how did the court in that case apply the law to the set of facts there? So you have rules, which is just a statement of the law. And then you have the analysis in the case, which is the court applying the law to the facts. So you extract the rules, you include those in your performance test. You then draft a rule proof, which is a statement, and I give you the formula here, about how the court ruled on a particular issue and why in the case in the library. Because we're going to use that rule proof when we do our own analysis of the facts of our case. So you want to, in step 4, you're reading the case, you're reading the library, and you're reading it very intentionally with a purpose. You're focusing on the analysis of each case, and you're assigning cases to their appropriate issues. And then you're identifying where you're going to draft your rule proofs. What issues get a rule proof? Not all issues get it. And then step 5, after you're done with that library, you actually draft your rules and your rule proofs. You draft them. And we're gonna actually walk through doing this for the February performance test. So please don't worry about that, because we're definitely going to walk through that. So you draft your rules, you just copy them basically verbatim from the cases in the library, or case or statutes, whatever it is. You can copy them verbatim. I get asked that question so much, and which I don't mind. But you can totally feel free to just write the rules. You have 90 minutes to complete this thing. Don't try to get fancy. In real life, if I'm writing to the court, or if I'm really writing, most statutes and things are written terribly. And a lot of times how a rule is stated in opinion is not stated well. So in real life, I would edit that. I would make it so that it's much easier to read without losing any meaning. But here, you just don't have time to do that. So all we are trying to do in a PT is write a decent first draft. That's it. That's really all it is. Just a decent first draft, something that makes sense. And you need to get through steps 1 through 5, really 1 through 6, so that you can focus on step 7, which is writing the analysis. So we really want you to focus on writing the analysis. That is key, key, key. And if you are finding that you run out of time before you get to step 7, or you don't have 25 minutes for step 7, you need to figure out where you are losing time. And I'll talk about the timing in a moment. But it is so key that I really just want to call it out here. So draft your rules and your rule proofs. Then once you're done with that, you've actually got like half of your PT written. You've got half of your PT written. Then you go back and you read the file and you read it in detail. And the reason you read the file here is because now you understand the significance of the facts in the file. Whereas this is why I just skim the file quickly. And then I go back, I go into the library to get an understanding. Yeah, absolutely. I go to the library to understand what facts are significant and how. And then I draft my rules and my rule proofs because then I'm done with the library. Then I don't need that like packet anymore. Then I go back and you read the file. And this, for me, often doesn't take 15 minutes. It's really like I'll combine sort of the reading the file and the writing the analysis. This usually doesn't take 15 minutes. I'm just trying to like really dissect the file and then so that I can get to writing my analysis. Time permitting, we'll proofread. Really realistically, I would proofread my headings and that's it. I might have 1 minute to do that because I would rather spend my time on the analysis. So let me talk about timing, and this is for a standard 90-minute PT. If you have an accommodation and you get additional time, then you would want to obviously modify these times. So reading the task memo, about 5 minutes. Setting up your skeletal outline, that's also about 5 minutes. Skimming the file, also about 5 minutes. So it's not getting, let's see. Oops, sorry. Okay. And yeah, Michael, I will talk about the rule proofs through example as we're working on them. I will absolutely get back and I will definitely talk about that as we're doing it. So skimming the file, that's about 5 minutes. We're about 15 minutes in, but you've also done some of your writing already because you've set up your skeletal outline. You're really getting a grasp on the whole task. Then skimming and reading the library. This is really where it gets kind of intensive. And what's really important is you know the difference between skimming and reading and what you can skip and what you can't. So I'm going to go through this. We're going to walk through the library and we're going to do a little bit of drafting today. And all right, everybody, I'm just going to pause for 1 second so that I can just grab him so it's not so noisy. I'm so sorry. Hold on, I'll be right back. Okay, I'm so sorry about that. Archie just gets very excited about PTs. All right. So I was on skimming and reading the library. This is about 15 minutes. It's about 15 minutes. And this is generally where I find people lose time. So you have to be careful not to do that. And the biggest tip I have for that is to not read those fact paragraphs at the beginning of the case. You can skip those. All of the really legally significant facts will be incorporated into the analysis. And we're going to read that very closely. So read each case with a purpose. Skip, don't get bogged down in the facts. Just skip it. I read the first line. So just reading the first line. Then we draft our rules and our rule proofs. So this is actually part of writing your PT. So this is great, is if you do this, if you follow these steps, at the halfway point at 45 minutes, you have like half of your PT written and you can just really focus on the analysis. I have a question if you have to use every case and statute in the file. You do have to use every case. You don't always have to use every statute. It really depends. If you get a ton of them, you're not going to use every statute. Yeah, generally speaking. All right, then after you've done that, you're at 45 minutes after step 5 and keep track of your time. Then you read the file and we're really trying to just dissect it and pull it apart to know, okay, what is this fact being used for? What is this fact being used for? Where does this go? Where does that go? So I want to really just sort of dissect my file. I'm not one of the things that I think that is different when I'm doing a PT versus when a lot of people that go over time versus what they do is if you are trying to understand everything as you read it, it's going to take you too long. I often don't fully understand something until I'm actually typing it and I'm making sense of it. So don't just like as long as you can identify, I think this goes here. That's really what's key. That's really key. So draft your rules and your rule proof. This is for me where the understanding comes in, drafting our rule proofs. We will walk through that. Then reading the file, and then writing the analysis. And this is so key. This is so key. This is really what a PT is about, is the analysis. You have to do a couple of things. You have to apply every rule to the facts of your case. You have to apply every necessary rule to the facts of your case. And you need to use the facts from and the reasoning from the case in the library or cases in your analysis. You need to make comparisons from our case to that case, because that's what courts care about. That's what courts care about. They don't care about what we think and what we just do when we just do a straight law fact application, unless there's nothing for us to compare it to. What the court cares about is what have other courts said? What have other courts said about this issue? And how have they applied the facts and come to a determination? So that's why we have to really, really use the facts of the cases. I see that there's a couple of questions, or those are hands up. Is that, if you can just type your questions in the chat, or I'm going to lower the hands. Okay. All right. All right, we're going to get into this February 2023 PT now. And just as a question, I saw there was a question, if you plan to sign up for the PT, the essay, etc. courses, there is a full study schedule that we provide. So we do provide a study schedule, etc. What we recently did is we bundled our courses together. So we have a PT course where I go and really dig into PTs. I have an essay course where I really dig into essays. And you have an archive, you have access to an archive of all the past essays that I've taught. And those classes start next weekend. And we have a schedule that started this past Monday, but I'm going to make another one that starts this coming week. That starts like at the end of the week, so that you're not late and you don't have to worry about getting caught up. All right. But yeah, we just put like a great bundle together of like everything for writing for the bar exam for $9.99. So if you have, it's everything, it's outlines, essays, PTs, the essay and PT workshops, the recorded version of them, all of that good stuff, a daily detailed study schedule, all of that. And it's $9.99. So, and there's some optional add-ons and stuff too, but all right. So let's get into this PT, and I'm going to switch over to my iPad. Let's do a new share. So I'm not going to be looking at the camera as much. I'm going to be looking at this. So I apologize for that, but I'm going to actually mark this up so it's like we're in the exam. Give me 1 second. Okay. There's not grading in the $9.99 package, but you can add that on. You can definitely add that on. And we actually modified our grading a little bit to make it a little bit easier and a little bit more flexible for you all too. Okay, can you all see that? Can you see the task memo? You should be able to. Okay, good. All right, so first thing we're gonna do, we have our task memo. So there are 5 things that you want to identify in your task memo. There are 5 things that you want to identify. And I make a note, and I always write in the top right corner of my documents. That way, if I'm flipping through quickly, I can like quickly see what I've got, like where is that document I'm looking for, so it makes it easy. So I make a note that this is my task memo. And then there are 5 things, like I said, that you want to analyze or that you want to identify here. And this is, I just remember TAPOS. Your tone, Is it objective or persuasive? Who's the audience? Who is the audience? Are you writing to your client? Are you writing to the court? Who are you writing to? Are you writing to opposing counsel? Who is it? Are you writing to your boss? All of those things. P. So sorry about my dog. He's being feistier than normal today. P is, what's the product that you're preparing? What's the product? Are you writing a letter to opposing counsel? Are you writing a letter to a client? Are you writing a brief? Are you writing a closing argument? And closing arguments are not that uncommon. They're not so common, but they're also not like uncommon. So you need to know how to do them. I wouldn't expect another one for July, but they are common. So you need to know all of the various formats. So what is the product, right? T, tone. A, audience, who are you writing to? P, what is the product that you're preparing? O, which is to me the biggest thing, is how are you organizing? What's your organizing principle? Are you organizing it by, client question? Are you organizing it by legal issue? Are you organizing by argument? How are you organizing? And often, very, very often, they tell you what the organizing principle is or what the issues are in the task memo. So we want to look for that. And S is, are there any special instructions? So, and a couple of special instructions that are very common. One is to, to draft a statement of facts or to not draft a statement of facts. Generally, I only draft a statement of facts if they tell me to. That's because otherwise I want to spend all my time in the analysis. The other thing that they will tell you is, especially if you're writing persuasively, is how to draft your headings. So how to draft your headings, usually they tell you that they need to have law and. What you want to look for, though, is if and all right, so let's look at this. Okay, is it better now? Sorry about that. Okay, sorry about that. Yeah, so what I said at the end was are there any special instructions? Are there any special instructions? So, are there any special instructions? Generally, this or two. They might give sorry, everybody, my Wi-Fi is having some issues. I'm so sorry. So, are you all back? Okay, good. Yeah, it just cut out for a minute here. Okay, I'm so sorry. So the S in special instructions, and this is getting fixed actually. So, all right. The last thing I was talking about was a format memo. So occasionally you'll get a document that is called a format memo. And what it is it is something from the firm that's giving you instructions and giving you detail on how to draft something. So if it's a statement of facts, or if it's a statement of facts, if it's how to draft your heading, if you're drafting a strange document, like if you're told to draft a will, how do you do that, etc. So occasionally you get a format memo. We haven't seen one in California since they switched to a 90-minute PT in July 2017. One quick note about that is California used to do 3-hour PTs. They used to do 3-hour PTs. They switched to 90 minutes in July 2017. Because of that, you should not practice any of the older 3-hour PTs. You should not practice any of those. All right. So let's get back to the task memo. Let me let this show. All right. What year? 2017. Yes, 2017. And while that loads, I will just grab him really quickly while this gets connected. Okay, so now we have our task memo up. So remember, we want to identify these 5 things, right? So let's do that. So defendant Sebastian Hughes is charged with murder after he fatally stabbed his uncle, Peter Galt, during a dispute over a Corvette car engine. Okay, so there's a defendant. I noticed that I'm in a criminal case, and I also notice here that I work for the state's attorney, so I work for the prosecution's office. So you want to keep, you want to always know who's your client, or who do you work for. The S stands for special instructions. So defendant Sebastian Hughes is charged with murder after he fatally stabbed his uncle, Peter Galt, during the dispute over a Corvette car engine. Defendant asserts he acted in self-defense. A centerpiece of our case against defendant is a recorded statement defendant made to detectives while he was in the hospital recovering from a stab wound inflicted by his uncle. Defendant originally moved to suppress the statement based on a failure to be given Miranda warnings. Okay, so there's a motion to suppress previously. The judge ruled in the state's favor on that motion. Defendant now argues, so this is what he's arguing now, that the statement was not voluntary and therefore should be excluded from his trial. The court decided that this new motion does not need to be briefed, but the court does want oral argument. So I'm like, uh-oh, I have to draft an oral argument. So, which makes people a little bit nervous, but you're okay. It's really basically the same as anything else. It really is the same as anything else. So please draft the oral argument. Please draft the oral argument. I will give an opposition to the suppression of the statement. So this is my task. And it's regarding the second one, that the statement was not voluntary. Okay. This is the motion. Our success depends on our ability to marshal the facts. Do not start with a statement of facts. So they tell us don't draft a statement of facts. So there's a special instruction, as you would if you were writing a brief. Rather, weave the specific facts into your argument as they relate to each of the elements of the controlling law. And it goes on to a second page here. Attached are the transcript of the recorded statement and a portion of the transcript where the court refused to suppress the statement on Miranda. Well, you are not to address the Miranda issue, so don't address the Miranda issue. The court's characterization of the interview may be helpful to your argument. Okay, so let's go back. What's the tone here? It's a closing argument, right? So tone is persuasive. Who's the audience? Who hears for oral arguments? The judge, the court. So that's the court. My product is an oral argument. Organizing principle, I don't know. I think that's what made this a little bit tricky, a little bit trickier than some other past performance tests, is because they don't tell you what the issues are. But when they don't tell you what the issues are, usually you're going to get that from the library. So I don't know yet. So I've got to figure that out. And that is my next thing I want to do. Any special instructions? So no Miranda and no statement of facts. Okay. Next thing I want to do is I want to set up my skeletal outline. It's going to be pretty skeletal at this point. So let's see here. Let me just get that open. Let's see. Let's just go here. Okay. Let's get my Word doc open. Okay, so now we're at step 2. We're drafting the skeletal outline, and I'm gonna go back and forth between my documents. All right, so after step 2, here we draft quickly, just a very short intro, very short conclusion, just keep it really, really, really brief. This is an oral argument, so you would say, good afternoon, may it please the court, for the reasons explained below, and tell us what you want. So the state, and we work for the state. So we are writing for the state. Remember that. A lot of people made a mistake on this PT and wrote for the wrong side. So keep track of that. You have to keep track of that. You have to know who you're writing for. So good afternoon, may it please the court, right? So the state respectfully requests the court deny defendant's motion to suppress a statement for lack of voluntariness. We're focused on this. Remember, we're not doing Miranda. Then I have a heading for my argument. It's okay to have headings in an oral argument that you write. I saw a lot of people that did this PT and put no headings in. And I see that commonly, that people think because it's an oral argument, you don't have headings. But when I'm giving an oral argument, I have headings for my points that I want to make. So you absolutely do in real life too. So then I just I don't usually, this is what I'm talking about for your organization. Usually I would know what these issues are. I would like to know that, but I don't know them yet. So I just put placeholders here, issue 1, issue 2. I don't know how many issues there are. I just put placeholders here. And then I make a little annotation here because the components for each issue are these. So you have your rule. This is your rule proof. Analysis. The rule proof, if applicable. You have your analysis. This is counter argument. You have to have counter arguments in every single PT. But if it's applicable to this issue, then I'm going to include one here. And this is a conclusion. Each of these is a separate paragraph. So you'll have as few as 3 paragraphs in here if you don't have a rule proof and if you don't have a counter argument. If it's a very simple, straightforward issue where it's just a straight law to fact application, and you might have a counter argument and a rule proof if it's a more detailed issue. And again, we will talk about writing these in a minute. So rule proof. So I just put, you don't have to label these and you don't leave these in here. This is just a placeholder for you because after I skim and read the library, I'm going to make annotations here. I'm like, okay, if I'm using for issue 2, whatever that is, if I'm getting things from the Smith case, I'm going to make a note. Okay, I'm using Smith here. So this is really, I say this a lot. Doing a PT is a lot like figuring out a puzzle, right? Except they don't tell you what the puzzle looks like. They don't tell you what the puzzle looks like. So you have to really start putting that picture together. And so you want to know where things go. You want to know where things go. So I want to know, well, what am I using? You know, why did they give me this case? Why did they give me this statute? What issues do they go to? So in step 4, we're making all these annotations. Okay. All right. I'm going to pause there for a second. Any questions? Anybody have any questions? I would do this in my physical, in my, I would do this like actually just on my computer. And yeah, you just go right into the rule. You can include a little like conclusion statement or a little intro sentence, but you don't have to. And no, you don't have any caption or any type of thing like that here at all. No, you don't do like the to from date Ray. I only do that if I'm writing a memo. Okay. All right. Let's see. And yeah, I definitely do this right in the doc. Yeah, at this point, I don't know how many issues I have. This is just a placeholder because I just want to keep in mind, like, because I'm in the exam, I do this stuff so that I don't forget to do it. I make these, so I'm like, all right, what am I using where? And I want to think about this stuff. I don't just want to not go in with a plan. And like, we forget stuff when we're in the heat of a test. So I do put like these placeholders in just so I know to put in a heading. I put these RPACC in so I know to do that stuff so that I don't forget. I don't forget, generally speaking, because I've done this a million times, which is also why it looks pretty easy when I do it. But yeah, so it's going to take you all, it's going to take a little bit of practice. It's going to take not even just a little bit, a lot of practice. No, and you're doing this all in, all of this is happening in ExamSoft. I'm doing it in Microsoft Word, but I can save it. But this is all happening in ExamSoft is where you would do it. You can't access anything outside of ExamSoft when you're in the exam. All right, in my skeletal outline, I'd also do a quick conclusion. Just based on the foregoing, the state respectfully requests you deny defendant's motion to suppress because the statement was voluntary. So just really like very brief, one sentence, very, very brief. Don't go in depth. If you have time at the end, like when you're proofreading, you can add to your intro, you can add to your conclusion. And ideally you would, but do you have to do that to pass? Absolutely not. All right. So that's step 2. Step 3, we're going to skim the file. So let me go back. Let me go back to the materials. And I don't know that I don't know how many issues are. I just put these in here as a placeholder. I just put these in here and because I don't know what they are. Ideally, it would tell me what the issues were and I would type in my headings at this point, but I don't know them. You know which side you're writing for because you're writing, your boss is the state's attorney. So let me show you. Let that switch back. Yeah, you could use the same conclusion if you came out the other way. You just change it from like, denied grant. So here, it's because our boss, oops, let's turn my iPad off. Our boss is a state's attorney. So that means we're working for the prosecution. And they tell us which side, they tell us which way to argue. It's a statement that I will give, which is our boss, the state's attorney, in opposition to the suppression of the statement. So if we're not working for the defendant, we're working for the prosecution. But yeah, a lot of people miss that. A lot of people didn't pick up on that on this exam. Okay, next we skim the file. So when I skim the file, all I am doing, a skim means I'm reading the first line of each paragraph and I'm just looking to see if anything really jumps off the page at me. And I'm labeling what I have. So first document, this is a transcript of the pretrial hearing. So pretrial. And in the book, when I mark everything, I did it much neater than I'm doing it here. I'm just doing it quickly here. Okay, and then I'm going to read the first line. So that's it. So let's first deal with the defense counsel's motion to exclude defendant's statement. Okay, so does defendant plan any other motions? Your Honor, defendant moves to exclude the statement made. Okay, and I do see here, like one thing that jumps off the page to me is that there's a U.S. Supreme Court case, Mincy, and that's it. Does a state stipulate to these facts? Which is, my boss. District attorney, we certainly do not stipulate to the allegations, so they don't stipulate. All right, as I said, I've listened to the recording of the statement, okay? And that's it, just really, really quickly. And then here's the transcript of the interview with Sebastian Hughes. Sebastian Hughes is the criminal defendant. So this is the statement at issue. So transcript of defendant. Okay, and when you get transcripts, you want to definitely practice with these, but still same thing. Just I really like, we're still skimming, and I really just like to read the first line. I like to read questions, and I like to read the first line of every big paragraph. Okay, so good evening, Mr. Hughes. I'm Detective Ray, and this is, if you mean Peter Galt, yes, he's dead. Mr. Hughes, this is my partner. We need to interview you. Let me just show you. Let me use the pointer. So It says here, I've got tubes in both my lungs and I'm a little drugged up, but yeah. Okay, we need to interview you. Our job is to come in when someone passes away. And notice here, like I'm like, okay, they say when someone passes away. We know that this is a murder charge. We know that this is a murder charge or there's been a death. But they're saying that when someone passes away, so they're being a little bit gentle with it. It's okay. So we're starting the interview with Mr. Sebastian Hughes and the surgical observation. So I'm like, oh, he just had surgery. Just for our record, Mr. Hughes, I want to describe what I see. Mr. Hughes is shirtless. Okay. Can you tell us what happened? So this is like, I always like to see these big, like open-ended questions because that's where I'm going to get a lot of my information from. Okay. I received a phone call from my mom's brother, Peter Galt, this morning around 11 o'clock. So I'm going to make a note of this. So this is like what happened. I heard my mom crying in the background. I feared for her safety. Hey, did you go directly? I really got to call my mom. Yeah, we'll get to that. So you were at work and decided to leave. I stopped at my work locker and placed an 8-inch wrench. Okay, and then I see that there's an unidentified voice. Excuse me, I'm from cardiology, need to draw some blood. Okay, so there's a break. And I see here you guys aren't leaving, are you? No, we're not going anywhere. So the defendant doesn't want these detectives to leave, which is like kind of curious. He wants to like get his statement in. No, we're not going anywhere. We'll turn off the tape while medical staff draws blood. Okay. Okay, we're back. We left off just as you were going to the house. Okay, so I'm just going to make a note. Going to house. Peter and my mom were standing in the driveway in front of his van. Peter was furious. Okay. We argued at first, then things got wild. Oops. Eventually, Peter knocks me to the ground. All right. So what happened then? I bent down and tried to pick up the wrench. Peter said, "You're not going to do." Okay. So there's that. Peter ran to the back doors of his van. I thought he was going to grab a knife. So he's really describing in detail what's going on here. I'm sorry. I guess I missed where your knife comes into the story. Okay. Yeah. I guess I forgot to mention that I got it from my work locker when I got the wrench. I realized I had been stabbed only when I saw blood all over myself and couldn't breathe. Do you think that if you didn't bring the knife, your uncle would be alive? Probably, but I would still be in the hospital. I know this was all self-defense, man. If I had not stabbed Peter, okay. So he's saying it's self-defense. We may do that, Mr. Hughes, but for now, I think we have enough. You've been generous. Okay. I may stay awake. I'm going to try to watch the University of Columbia game. So after this like interrogation, after this questioning, then he's like, all right, I'm going to watch a basketball game. Or I'm assuming it's a basketball game. I don't know why. Maybe because it's February. All right. And then interview concludes at 8:20. They're giving us times and details because they're important. And that's it. So that's just a quick skim of the file. I have a sort of sense of what's going on, of what this interview looked like, but I just want to know, and like, does anything jump out in particular? Now I want to go on to step 4. And remember, I still don't know how I'm organizing it, but I do see there's only one case. Generally speaking, you want to look to how, if you're not given the organization, then you want to look to see how the court organized the issues in the library in your case. Or if you have like elements, then you're going to organize by element, etc. Okay. So give me 1 second here. Let's actually just take a quick pause because we're going to jump into reading the case. So let's just take like 2 or 3 minutes and we'll get into this. All right. Okay, I still want to give people another minute or two, but I just wanted to check in to see if there's any questions at this point before we dig into the library, and give people just a minute because we've been going for a little while. Any questions? All right, are y'all still there? Oh, let's see. Yes, and these do apply for handwritten PT as well. Absolutely. Okay, you're there. Okay, good. Sorry about that. My headphones had just died. So I was starting to read the library, so I wanted to grab another set. Okay, good. All right. So let's dig into this. Now let's start digging into this. So again, I always like to label in the top right corner on the first page, whatever document I have. There's only one case here. So I'm just going to make a note though, just because it's habit. And I notice that this is Columbia Supreme Court. Yeah, and this is, yeah, and this is definitely going to be relevant. So here, I want to show you really how do you skim and then read the library. So skimming and reading. We read the first line, just like we just did with the skim of the file. We just read the first line of each paragraph. And if it's a fact paragraph, like at the beginning, if it's a fact paragraph prior to the procedural history, then if it's a fact paragraph prior to the procedural history, I'm not reading it. I'm just reading the first line and I'm not going to go back and read it at all. So here, the defendant Garrison Perdomo was involved in a single car accident in which this is just facts. After a night of heavy drinking at around 2:45 a.m. on August 23rd, 2003, this is just facts. Defendant based his defense. All right. So, and this is actually where we start getting into a little bit of procedure, because now I'm like, this is talking about the facts behind the case. This is saying what happened in court. So I could just skip these two whole paragraphs. And the reason that's really important is because people get so bogged down in understanding all of these facts when the really significant facts are in the analysis of the case. They will be there for you. All right. And you only need to write the oral argument. That's correct. You don't have to write a note to the state attorney and closing it. That's correct. You just write the actual oral argument. So now I'm going to start reading more closely. Defendant based his defense on the Marco was driving. Defendant to exclude the evidence of inculpatory statements he made to the police officers. Near the end of the interview, defendant admitted he sometimes smoked marijuana and then said, "Maybe that day I was smoking. I'm not going to mess with you guys. I was driving Marco's car." Defendant argued that admission of his statement violated his 5th and 14th Amendment rights to a fair trial. He claims it was error of constitutional dimension to admit statements he made to officers who interrogated him in the intensive care unit of the hospital while he was recovering from surgery and heavily sedated with narcotic pain medications. And I got a question, are all California PTs digital? No, they're not digital, actually. I'm just doing it digitally because of the presentation. You get hard copies, and that's why I'm actually doing it on my iPad, so I can mark it up just like you will do in real life. All right, in the exam. All right. Defendant suffered severe traumatic injuries to his chest area. Several of his ribs were fractured. He underwent emergency surgery to remove his spleen. He also had some bleeding in his brain, so really severe injuries. 4 days after the accident and defendant's surgery, medical personnel in the ICU of the hospital finally granted Officer Laubscher, I don't know, and his partner, Officer Jensen, permission to speak to defendant. So this is 4 days later. Medical personnel directed the officers to keep their discussion brief, said to keep it brief. Around 6:30 a.m., the officers interviewed defendant in the intensive care unit of the hospital. The interview was tape recorded. Defendant was lying flat on the bed, recovering from the splenectomy, broken ribs, and head injury. He was in obvious pain. Defendant had received his last pain medication 5.5 hours earlier. He was still connected to intravenous solutions and monitors. He had been on a ventilator since the surgery, but this device had been removed the day before, and he was breathing on his own. Defendant's speech was slow and deliberate, but not slurred or overly raspy from the intubation. The officer's questions were also slow, subdued, and deliberate. The interview, with numerous pauses, lasted approximately 20 minutes, not terribly long. The officers questioned defendant about the events occurring before and after the accident. Defendant's answers were responsive to the officer's questions. Most significantly, according to Officer Jensen, who was present and later transcribed the tape, and just to follow along, I'm right here. Defendant admitted he'd been driving the car when the accident occurred. And then his switches. This is a rule. This is where I really slow down. And I just like to label it rule and put brackets around it. If some of you may have seen me do other videos on YouTube, and I'm talking specifically about like highlighting and using different colors. We don't do that necessarily anymore. That was when the PT was given just online, when it was a remotely administered exam due to COVID, which is not the case anymore. So don't worry about that. I just like to label it, keep it simple. So here's the rule. A statement is involuntary if it is not the product of a rational intellect and free will. I'm highlighting just for demonstrative purposes, but you really don't need to do this in the exam. You can, but it's just not totally necessary. The question posed by the due process clause in cases of claimed psychological coercion is whether the influences brought to bear upon the accused were such as to overbear petitioner's will to resist and bring about confessions not freely self-determined. Okay, so that's rule. And then here's more rule. So I label each paragraph so that I know where to grab the rules from, because I don't want to have to go back and dig through. That's what I don't want to do. When I'm writing my rules and my rule proof, I want to go grab them. I want to go grab them really quickly. I don't want to dig through it to find it. All right, and here I start to see some stuff that is numbered, and that tells me that's probably my organization. I see here there's 1 and 2. So in determining whether or not an accused's will is overborne, an examination must be made of all the surrounding circumstances, including the characteristics of the accused, including such factors as a defendant's maturity, education, physical condition, and mental health, including mental acuity. And 2, the details of the interrogation that indicate coercion, which include the length of the interrogation, the location of the interrogation, and the interrogation's continuity. Additional factors that might indicate coercion include whether the officers dominated or controlled the course of the interrogation, whether they allowed defendant to tell his story, then asked follow-up questions to clarify the details, whether their questions were open-ended and neither aggressive nor particularly accusatory in nature, and whether there is evidence that the officers had or drew weapons or otherwise employed threatening or intimidating interrogation tactics. No single factor is dispositive. So there's all these factors. I could highlight the whole thing, but this gives me my organization. And you could break this up two ways. You could just do it based on the characteristics of the accused and the details of the interrogation, which is really how they do it here. You could also add additional factors, but I think really the additional factors go towards the detail of the interrogation. So I just did it all in one, but you could do it in 3 little sections if you wanted to. All right, so defendant asserts that there are numerous parallels between his case and the factual circumstances of Mincy v. Arizona. So there's this other case, right? This big case, Mincy, sufficient to find his statements involuntary and require reversal of his convictions. And then look, this is how they organize it. We want to just copy this organization, surrounding circumstances. So characteristics of the accused, and I just want to look briefly. And then they do, oops, I forgot to, I've obviously done this before. Details of the interrogation. So I notice here that they break it up into characteristics of the accused and details of the interrogation. Okay, so I want to look at this. What do they say? They say in Mincy v. Arizona, Mincy was shot in the hip by police officers. So I'm just going to make a note. This is Mincy. Shot in the hip by police officers in a raid on his apartment. Mincy was transported to the hospital where he received emergency treatment. When he arrived at the hospital, he was almost to the point of coma. So this is really, they're giving you a case within a case. So they really gave us 2 cases here. Instead they just put it all into one big case. But they really gave us Mincy and they gave us Perdomo. So there's 2 cases to use here. All right. When he arrived at the hospital, he was almost to the point of coma. The shot caused damage to the sciatic nerve and partial paralysis of his right leg. Tubes were inserted into his throat, I'm right here, to help him breathe, and through his nose into his stomach to keep him from vomiting. A catheter was inserted into his bladder. He received various drugs and medical personnel attached a device to his arm so he could be fed intravenously. Mincy was then moved from the emergency room into the ICU. Around 8 p.m., a police detective came to the ICU to interrogate Mincy. The detective told Mincy he was under arrest for murder of the police officer. I already know that. I don't think that they did that in that case. He gave Miranda warnings to Mincy and then started questioning him about the activities and shooting at his apartment. So here they're talking about, this is the interrogation. And Mincy. He responded to the detective's question by writing answers on pieces of paper. The detective continued to question Mincy until almost midnight, so 4 hours. During the interrogation, Mincy repeatedly asked for the interrogation to cease. Repeatedly asked for the interrogation to cease. Like our guy asked, you guys aren't stop leaving, are you? Right. So I already see a big contrast there. Several times Mincy requested the assistance of counsel before responding. He complained to the detective that the pain in his leg was unbearable. Some of Mincy's written responses were incoherent and on their face showed he was confused and unable to think clearly about the events in his apartment or the interrogation. The Supreme Court concluded Mincy's statements were not the product of his free and rational choice, and this is what they say. So this I'm going to use in my rule proof. To the contrary, the undisputed evidence makes clear that Mincy wanted not to answer Detective Hust, but Mincy was weakened by pain and shock, isolated from family, friends, and legal counsel, and barely conscious, and his will was simply overborne. Due process of law requires that the statements obtained as these were cannot be used in any way against a defendant at his trial. Okay, so this is all giving me all of the context of Mincy. It's really giving me another case here. And then here is the analysis. So this is interrogation Mincy. All of this, all of this is like the analysis of Mincy. And I use the analysis in the cases to draft a rule proof. That's what I use them for. That's why I'm labeling it. So I know I'm going to do a rule proof. I'm going to use this. And then here is the analysis of Perdomo, which is the case we're in. Like the situation in Mincy, here, defendant was questioned while lying in a hospital bed in the ICU. So similar. As in Mincy, no family members or friends were with him, were then with him. He was recovering from surgery for the injuries he received 4 days earlier. Intravenous tubes were still attached to his body. Defendant had been receiving narcotic pain medication since his admission to the hospital. According to the interrogating officers, defendant appeared to be in pain and also appeared to still be under the influence of narcotic pain medication. However, and as soon as I see that however, I'm like, all right, they're switching gears. They're going to say it's different. However, this is where the similarities end. So I know that Perdomo is going to come out the opposite of Mincy. I know that it's going to come out the opposite of Mincy. So what that tells me is because I want the same result, in Mincy, the court held that the statements were not voluntary. I'm arguing that the statements here were voluntary. So I'm going to distinguish from Mincy, and this case is going to go the same way that I want. So I'm going to analogize to Perdomo. All right. So here is analysis. So unlike what occurred in Mincy, defendant was not interrogated within hours of his injuries and not interrogated only a few hours after receiving medical treatment. Also, unlike in Mincy, defendant was not interrogated while going in and out of consciousness. In this case, the officers were not permitted to interview defendant until 4 days after defendant's surgery. So it was later. Hospital personnel did not permit the officers to talk to defendant until they determined he was alert, oriented, and could obey commands. So he's alert and oriented, as indicated by his medical chart. By this time, defendant no longer needed the assistance of a respirator, and medical personnel had removed it the day before the interview. On the day of the interview, hospital staff determined defendant's condition had improved sufficiently so that he could safely be cared for in a regular hospital room. At 8:30 a.m., so this is like regular hospital room. At 8:30 a.m. and 2 hours after the interview, defendant was moved out of the ICU, taken off intravenous pain medications, and thereafter given oral doses of Vicodin for pain as needed. So he's still taking pain medication, right? He's still taking pain medication, but it's not as serious. The medical professionals have said, you know, he can talk to the police. He's okay, so sufficiently okay. The evidence showed defendant was probably still under the influence of the pain medications, although the effect of the morphine he received 5.5 hours earlier had likely diminished over the hours. So he's still even under the influence of the morphine. Nothing on the tape shows defendants thinking. This is really the analysis and like reasoning. Nothing on the tape shows defendant's thinking was impaired by the medication. Defendant's speech is slow and deliberate, but is not slurred or incoherent. Each of defendant's answers is appropriate to the question asked. In some instances, his answers were detailed. For example, when asked the name of the security company for which they all worked, and even recited the company's phone number. At the beginning of the tape, it appears defendant was even alert enough to attempt to deceive the officers. He initially told the officers the night of the accident that he had been driving his mother's Nissan alone and without passengers. He later acknowledged being with Rodriguez and Quinonez's mother's Honda. So that's really the analysis. So I'm keeping track. So there's a lot going on here. This is just one very dense case. It's really like we're reading two cases at once. Then we're going to look at Mincy. We're going to look at the second issue, details of the interrogation. In Mincy, so now they go back to Mincy. So this is really important. This means we need to compare to Mincy and Perdomo on both issues. So we need to do a lot here. There's a lot going on. There's a lot to analyze. In Mincy, the detective ceased the interrogation only during the interviews when Mincy lost consciousness or received medical treatment, and after each such interruption, returned relentlessly to his task. So I think that's interesting. They use the word relentlessly. The statements at issue were thus the result of virtually continuous questioning of a seriously and painfully wounded man on the edge of consciousness. Most importantly, the interrogation in the present case, okay, so now we're getting to Perdomo and the analysis. The interrogation in the present case exhibits none of the coercive police activity found in Mincy and other cases finding statements to have been involuntary. The interview in the present case was relatively short. It lasted a maximum of 20 minutes. Ours was short too, I think, as compared to the 3 hours Mincy was forced to endure. The officers in the present case posed their questions in a calm, deliberate manner. The officers' voices on the tape are very quiet and subdued, perhaps in deference to the other patients in the unit, and or because of the relative lack of privacy in the room. The 20-minute interview includes several pauses as well, as medical personnel enter and exit the room providing treatment for the other patients. Unlike Mincy, who had asked for the interrogation to cease and had refused to answer some questions without the assistance of counsel, defendant made no such request and did not express distress or otherwise indicate any unwillingness to speak to the officers. As the trial court noted, the officer's tone was conversational and not threatening. One of the subjects discussed how supportive and attentive defendant's mother had been. Defendant expressed gratitude for his recovery. He asked the officers questions regarding his friend's conditions. At the end of the tape, the officers wished defendant good luck and a speedy recovery. In short, the record is devoid of any suggestion the officers resorted to physical or psychological pressure to elicit statements from defendant. Absent some indication of coercive police activity, an admission or confession cannot be deemed involuntary within the due process clause of the 14th Amendment. The judgment is affirmed. All right. So we just dug that, right? And I actually did read that, like go through the library and skim and read it in 15 minutes. So even though I'm reading it out loud, which takes longer than if you're just reading it to yourself and marking it up. So let me do this. I'm gonna send this to all right. Yeah, so how do you know to read almost all the facts for Mincy? It's really because, let's see. It's because doing procedural history. So I don't want to take any risks of like not reading it. So I do read them all here. Okay, all right. Let me get back to my Word doc. Okay. All right, so now you should be able to see both the Word doc that I have here and my PT that I marked up, that I just marked up. Okay, I'm going to go down here. So first thing I want to do is it's 2 issues. So I'm going to delete issue 3 here. Okay, issue 1. And I like to write my headings persuasively. So the statement was voluntary because, and what was the first issue? Statement was voluntary, characteristics of the accused. Yeah. Because the characteristics of the accused demonstrated no coercion. Something like that. We can do whatever. It doesn't really matter. A persuasive heading is one that actually states a conclusion. An objective heading generally has the word whether in it. And again, I go in so much detail to all of this stuff, give you samples and formulas and just everything in my PT book, and walk you through all of the other California PTs, all of the other 90-minute ones. So you should definitely check out that book if you don't have it. Let's see. And I put the link up here before. Let me just put it here again. It's just in the heading you do that. It's not even that important though, that you capitalize every word. Okay, so here, like as I was going, so this is just a slight difference from when you're in the exam. As I'm going through the library, I'm making a note of what goes where. So step 4 really happens as you read. So I'm gonna make a note. So my rule for, and you can do this too. So like here, I'm gonna put my major rule. So just, which comes from Perdomo. So this is that rule that was this big rule, Perdomo. So this rule from regarding voluntariness, actually Mincy. And you don't have to say like Mincy cited in Perdomo or Perdomo citing Mincy. You don't have to do that. Just cite the case that it came from, the original one. That doesn't matter. So here, my rule is coming from Perdomo and Mincy. Rule proof, I'm doing both. Analysis, I'm going to distinguish from Mincy, analogize to Perdomo. And same thing below. This is really all the same. So I can just copy this and put that down there. So it's really all the same here. All right. So as you're reading the library, you would be making these annotation of what goes where. You'd be making those notes. All right. Sorry, I keep hitting. Put that away. All right. So then I want to draft my rules and my rule proof. So a couple of, you can really just pull them as they are. You could do this a couple of different ways here. You could just take all of this rule and put it at the outset. So you could do all of it right here. But what I have to do is if there is a particular rule that goes to a particular issue, and well, let me just take a step back. Here, it's a little bit tough to parse what goes where. It's a little bit tough to parse what goes where. So if you wanted, you could just lead with everything here. And this requires a tiny bit of editing. You could say, okay, well, part of this, huge sentence, it goes to the first issue, the characteristics of the accused. Oh, and I have to do this. Was the details of the no coercion. That's fine. So in here, I want to sort of like pull what rule is relevant to which issue. So, but you could do it either way. You could do it really either way. So I'm going to write in my rules, and I'm going to talk about writing the rule proofs, even though I have already drafted. So then, so this is really what it would look like after step 4. And you could add Mincy in here too. So then after step 5, this is where you actually write in the rules. And I'm going through this a little bit quickly just to not keep this into like a full 3-hour session. I'm just grabbing the rules from here and typing it in. You know, a better PT, like, so my approach to teaching is I want to show you just how to pass, right? I don't want to just be like, oh, here is an absolute perfect one, figure out how to get there. Let's talk and like learn how to go from a 55 to a 60 to a 65 to a 70, 75 and beyond, right? So like, let's go incrementally up instead of just starting like, this is what the top is and you figure out how to get there. I want to walk you through how to get there. So I just basically copy the rules here. I separated them out a little bit, including like the detail of the characteristics of the accused I put here. But you could have put, like I said, all the rules straight up here. You could have absolutely done that. And the model answer of this, my model answer will be available in our free workshops course. So you can access it there when we're done, or not when we're done. It'll take us like a day or two once we upload the video and all that. A better, what I was starting to say was a better answer will actually take the rules if they're written one way, if they don't go in our favor, and we'll actually flip them and write them in a more persuasive way without changing the meaning. I do demonstrate how to do that, how we could do that in the course. I'm not going to do it here. And it's definitely a more advanced strategy that you don't need to worry about if you're not finishing a PT. The very first thing you need to know is, how do I just finish this thing and answer the question, right? Because that gets you basically a 60, as long as you like get the appropriate stuff and you actually like might not be finished to what you want. You might not have been able to make every argument, but it's done. You've answered the question, which is key. Yeah, so that's what I really wanted to focus on today. So I typed in my rules. So I have a rule, which I pulled from Perdomo, and really all the rule is right here. And then the portion of the rule for the characteristics of the accused, I typed in here. And I'm going to walk through writing the rule proofs. And then the rule here, which is the details of the interrogation, which is really all of this, I just copied and I put right here, and that's it. So just put in your rules, right? But as I'm putting it in, I'm like, what are all the components? Because one of the biggest errors that I see people make is they don't analyze every part of the rule. There's a ton of factors here. There's a ton. And they say no single factor is dispositive. And they might not analyze all of the factors in the actual case, but you need to address all of them and say which way does this factor weigh? Does this weigh toward voluntariness or does it weigh towards coercion? So you need to make sure that you do that. You're not just comparing to the facts and the reasoning in the cases. You are also saying, okay, if there's something they didn't analyze because it wasn't relevant in that case, do I need to analyze it here? And you do. You need to mention it at least. Okay. Now, I want to take what I wrote here with Mincy. I want to take what I wrote here and write a rule proof. So let's just do it for, I think I'm not going to do it for both issues today because you can read it. I just want to demonstrate how. In the full classes, I do go in a lot deeper. Okay, so we're just going to take Mincy. We're going to say what happened in Mincy. So let's see, let me just go to the end. There's my final draft. Okay, so rule proofs are basically this formula. Let me make it a little bit bigger. Right, and you put the case name. The court held, holding Ray, issue in heading, because facts and reasoning, and sometimes policy, whatever. Okay, so first step in Mincy. Okay, then I say the court held. So I'm talking here about the details of the interrogation, right? How did the court hold the details of the interrogation demonstrated whether the statement was obtained voluntarily? When I say the holding regarding the issue in the heading, I'm talking about the issue that I'm writing under. So like the details of the interrogation. How did they hold regarding this particular issue? Not the whole thing, just the details of the interrogation. So in Mincy, the court held the details of the interrogation demonstrated the statement was obtained voluntarily because, so the court held, So holding right issue, I'm going to do this. And then let's do a different color. Then we have because here, because here. Okay, so why? Why did they say that? Why did they say that? So I'm just going to take this little paragraph. So because the detective in that case ceased and I'm not going to fix little typos because perfection's the enemy of completion, only during the intervals when, and here they're referring to Mincy by name. He's the criminal defendant or the accused. So I'm just going to use, we always want to turn these people into like their legal title because it makes it easier because you don't want to have to keep track of who all these people are, these names. The check when the treatment and after each, I'm going to pause for a second because of my Wi-Fi. Okay, is it better now? Okay, it's better now. Okay, good. And after each, okay, thanks. Sorry about that. When the defendant was to receive medical treatment and after each such interruption returned relentlessly to his task. And like we're not going to just type it exactly as it's written. I'm going to connect it. I make my rule proofs basically one sentence unless it's just way too long. So I say, so it says the statements at issue were thus the result of virtually continuous questioning of a seriously and painfully wounded man on the edge of consciousness. So I'm going to return relentlessly to his task, and as such, the statements were the result of virtually continuous questioning of a seriously and painfully wounded man on the edge of consciousness. Okay, so that's my rule proof, right? Because facts, reasoning, sometimes policy, all of the stuff that is in what I've labeled as the analysis, right? And it's generally like the biggest part of the rule proof. It's a lot. It's a lot. And then that way I don't have to look back at the case. When I'm writing my analysis, I'm going to look at my facts of my case. Are they similar to or different from, and why? And I'm going to include a lot of detail for my case. So let's have all of you use this formula to write. And this is what I do in class a lot. This is a benefit of coming to class live versus attending it recorded, is I'm going to have all of you attempt to write a rule proof, right? But there's a lot here. I'm going to give you all like 5 minutes, maybe a little bit longer. Write the rule proof here, which is really all of this. You don't have to do all of it. You can be selective. And then I'll show you what I did. So write the rule proof and then send it to me. You can put it to me, like to the host panelists in the chat. So I'm going to give you a few minutes. Go for it. Write it. Actually, let's do this. Let's do it together a little. What should the start of it be? So I just want you to do, I want you to exclude the blue for now. Just do this part and send that to me first. But what about the part in yellow? And you can just look at what's on my screen, but I'm putting it in the chat again as well. The difference between the rule proof and the analysis is that the analysis is about our case, whereas the rule proof is about the case in the library. That's the difference. Good, Anna, that's perfect. Good, Sahar, that's great. But you have to keep, what is the detail in the heading that we're looking at here? The February, this one, actually, I'm updating PT book. The nice thing is I can always, the way that I do it, I can always update it. So I am answering, or I'm adding this to the book as well. Yeah, so that'll be available in the next, I don't know, week or two. The difference between the rule and the rule proof is a rule is just stating what the rule is. The rule proof is demonstrating how that rule was applied to the facts of the case in the library, right? So for example, the rule might be it's illegal to drive more than 65 miles an hour, right? The rule proof would be in case name, in Smith, the court held the defendant drove more than 65 miles an hour because he was driving 80 miles an hour. That's the difference. One is just a straight rule. The other one is explaining how the rule is applied to the facts of the case in the library. And yeah, the book updates automatically. So if I make a change to it, you get the change. So yeah, so even if you buy the book now, the book will update automatically. You won't even know. Although we'll send out an update and let people know. But yeah, it'll be in there. And yeah, so if you get the book today, you'll get this PT in it as well. Yeah, I love the way that it works. Let's see some of these. Yeah, Letitia, good. And remember, Letitia, we also want to tie it back to the voluntariness, but that's good. Good, Carla, that's great. Good. Really, really good. Yeah, Marcella, that's great. My Wi-Fi is being a little slow, so I'm going to pause. Send me, if you're writing it, send it to me. I'm going to give you all another few minutes. And then if you already sent me the first part, I'll add in the facts and reasoning, etc. And you can resend it. Aline, that's good, but we want to add a lot more detail there. And Aline, I think you actually referenced, you want to do the other case. Good, Sonali, that's great. We want to get a little bit more in there, but that's really good. Yeah, you can send it in the chat. Yep. And remember to include like the details of the interrogation as part of but it's not a big deal, but that's okay. But I like to do that. Good, Carla. Good, Kyla. Good, Anya. Make sure you get the right case name though. Good, Catherine. Good, Martucci. That's okay. It happens. Good, Maria. That's great. I like how you incorporated Mincy into it too. That's great. Nima, that's great. Hi, Marta. Good, Marta. Good, Desi. Really good. It's not necessary, Catherine, but if you can. Kathleen, that's great. And everybody, people are doing it different ways. That's totally fine. It's completely, completely fine. Good, Keela. All right. So now I'm going to show you all mine. So here's, here I have Mincy and Perdomo, and I could add a lot more facts in here, and a better answer would incorporate a lot more facts. But again, make sure I want you to finish first, and then we'll talk. Like, make sure you can finish your PT in time, and then we talk about how do you get a higher score. All right. And I go into that in the class, I went into it in the book, etc. All right. And I'm not going to get into all of these parts today, but because it's generally speaking, writing the analysis is what I think most of us, if you're a foreign trained lawyer, you know how to write analysis, or you definitely should know how to do that. And if you've gone through law school, that's also like the key part. And I'm assuming that it's the rest of it. It's the figuring of it out. It's, doing the rules, explaining what happened in the cases, what I call the rule proof, etc. That's the key. So you would do the next couple of steps, and you can see my final version of this. It will be uploaded for everybody. You can see my analysis, how you can see how I do my analysis, etc. In here. And I also just want to point out one thing. Mine's only 1,250 words. I see people, and that's not because that's like how long it needs to be. But I know the selected answers on the State Bar website are much longer than this. That's okay. I write very densely, and I try to really not include any extraneous. And that's even without editing. I would edit this down, and I could probably cut another 200 words. But I just wanted to point out that these don't have to be really long and complicated. Mine is a definite, solid answer, definitely passing, and probably with some cushion there. Yeah. And if I wanted to make this higher, I would incorporate more facts. I would make more comparisons. But what I did do in my analysis is I made sure that I addressed every single factor, and I made sure to use both cases in both issues. And Catherine, I know it's tough as a foreign trained lawyer. I know that it can be really tough, but that's why I actually, when I wrote the PT book, I was really thinking about, I've worked with so many foreign trained lawyers in preparing them for the bar exam. And I always try to write my books, my materials directly towards them. And on that note, towards a foreign trained lawyer, and then anybody else that, that maybe it's been a while. On that note, I want to show you all just really briefly. I don't know if you guys know, but I have an essay book that is coming out. I have an essay book that's coming out. It's coming June 1st. I'm really, really excited for it. You can get a free sample of it. I will post that link in the chat if you haven't seen it yet. Let me just go back. Have you guys seen it? Have you guys seen the sample of it? Anybody here seen it? Oh, so here is the link. And it'll be available June 1st. Oh, Starlit, good. It'll be available June 1st. I'm really, really excited. And I'm going to show you the sample here. So it's in the same format again. One second. Let me pause. Just give me 1 minute. I've been working on this like crazy. So it'll pull up in just a second here. Okay. All right. So you can see it here. You can ignore the stuff on the left. Here's a sample. that subject. Rules with a lot of hints on, not hints, but showing you time-saving tips and strategies. I write pretty simply. I tell you exactly what you need to include in your analysis, etc. I show you also, like, here's a good example. Here, if you had a tour essay and you're writing about assault, I show you how you do it, if it was a huge issue. But I also show you how do you do that issue quickly? How do you do that issue really quickly? And that's here. So like a truncated little version of it. So I show stuff like that. Let me also go. So every issue is in here with really helpful footnotes. From my years of teaching and tutoring and writing answers and looking at people's answers and scores, etc. For every topic or most topics, I give you a little blurb on common things that come up with that. And again, these footnotes are really key. This is what I wanted to show you. I will also, when you see grayed out text, that means you don't necessarily need to include that. So it's something you only include if it's applicable, or you only include if you have time. Sometimes it's just like, giving a definition and then getting to the elements. Sometimes you can omit the definition. It's okay. Here, for example, comparative fault, there's a ton of detail to the rule, but you don't really need all of it. So I just show you what you can kind of cut out. So for those of you that run out of time, or, that's a huge issue. So I really wanted to address that. This book is really a strategy book. It's really a lot about how you write the analysis. Yes, it's rules, and it's lots of that. It's a lot of rules and stuff, and it's showing you how you do structure and organize everything. And I do this for every subject. So we're just making some last edits to it. But it's just got tons of detail. And the other thing that's nice about this too is, like the PT book, if you get this and, maybe I make an edit to it, maybe I'm like, oh, there's this other tip, because I'm working a lot throughout the bar cycle, and I might notice another tip I want to include. I might add that, and I can send everybody that has it an email saying, hey, we just added this thing, or hey, there's this issue that doesn't come up very much, and I saw that people wanted it, so I'm adding it to the book. Because I have to make decisions about what am I going to include and what I'm going to exclude, to make it not just absolutely insane. But if there's something I see that a lot of people have a question about, I can add to it. And I can do that based on a lot of different things. So took a lot of care to really check that stuff out. Writing, how do you do this? How do you do all these different things? So just wanted to mention that. Also, as a reminder, I'm doing a free essay workshop tomorrow. We're doing some other workshops coming up in the next couple of weeks. Make sure you are on our email list. If you signed up for this workshop, we'll add you to that. One other quick little thing that I'm very excited about. A ton of people like audio recordings, and want to be able to listen to something while they're driving. I am starting to record tips and tricks and adding them to a podcast. So you'll be able to listen to that as well if you want something to listen to while you're on a walk, which sounds horrible to me, but some people, while you're studying, can make the day a little bit, easier, can make studying easier. So I'm doing a podcast. So I've already recorded the first few episodes, are being uploaded. We'll send out a link so you can listen to that as well. Just lots of tips on, repeating our strategy. And then, like today, I talked all about some big things in civil procedure. So just be on the lookout for that. All right, everybody. Thank you so much for joining tonight. I hope you found the class helpful. And as a reminder, that PT book, if you found this helpful, I go so in depth in the PT book, and I go more in depth in the PT course. Those are starting for a week. Also, if you haven't had a chance to talk with me or a member of my team about your scores, you can definitely still do that. So just send us an email, hello@bar-md.com, and we'll get back to you. We will definitely get back to you if you want to have a score review. All right. Thank you, everybody. Thank you so much. And it's just really nice. And sorry about my dog being so loud earlier and my little bit of shaky Wi-Fi, but I really appreciate you all hanging in here. And if you need anything at all, please feel free to reach out. I hope to see you in class. I hope you love the book. Thanks. And thank you again. Thank you so much, everybody. Hopefully I'll see you soon. Bye.